Mr. Helmers, Mr. Waterman told us that the legislature has made the determination and has set that irrebuttable presumption in legislation. Do you agree with that?
No, sir.
Now tell me how you don't agree with that.
Justice Minton, it's just not there. One can look at the statutory language, and there is no irrebuttable presumption. In fact, the cases that have come out have specifically stated that it's rebuttable. Tackett versus Tackett, Commonwealth versus Bartlett, most recently Boone versus Ballinger, indicate that the statute, the presumption is rebuttable.
Those have all been cases, if I'm correct about that, those are all cases, the parties to it have been married. Haven't they been parties to the marriage?
Yes, sir. Although in the most recent case, Boone versus Ballinger, which sort of wraps up the history of the jurisprudence on this issue, the actual father, that is the biological father, was represented by Mrs. Ballinger, who then became married to him. The situations are in every case messy, but there's something that we need to deal with. Additionally, I'd like to take up the issue of whether there's a stigma attached to these children.
Before you get to that, let me get to an issue you're all supporting arguments. I counted about 17 states, including Illinois, that connects to us, in Tennessee, and 15 others cited by the appellant that supported the position that the 406-011 presumption is rebuttable within the marriage, but it's irrebuttable to strangers, by strangers to the marriage. And we've talked about the Ballinger case, but do you have any other cases that take your position?
Well, certainly no Kentucky cases.
Do you have any other states, especially any sister states, that take your position?
Well, I think the best synopsis of the answer to your question is found in the Zupanik treatise that says that the general trend is to recognize fatherhood as being that which relates to the biological father.
Is that under the Uniform Act?
Well, there are many uniform acts, but under Kentucky's Uniform Paternity Act, I think it can clearly be read that, as Professor Graham and Justice Keller have written, that biology trumps the marital presumption.
When proven. When proven, when established.
When established. I was going to take up this.
Counsel, there seems to have been an assumption made, perhaps by you and also by opposing counsel, and maybe some members of the court, me included, that the question that we're dealing with here would necessarily govern the outcome of questions of inheritance. And I'm wondering about that. Suppose a court in Kentucky made a determination that the putative father in this case could not, lack standing to attack or to assert his right of paternity in the child. Would that necessarily foreclose the child from seeking, perhaps at some later time when that child became an adult, perhaps, would that foreclose that child from seeking to establish his own paternity? In other words, I'm saying, does the initial determination that we're being asked to make, does that necessarily answer the inheritance question?
Not, to be honest, I don't know that we've addressed it within the briefs, but I think that it's important to know that I think that a child should have some type of protection to determine his or her own identity. And I would agree with, I think, what you're asking, which is the child should be able to bring that action. Just 2 weeks ago, we had a summit on children in Louisville, and one of the speakers talked about the fact that children should have some type of rights. Those haven't been taken up in the Kentucky legislature or passed as constitutional amendments. But I think in the event that it is, the right to know his or her identity is one of the rights that I think children should have. There are biological reasons for this, okay? But what we've seen in the cases that have come up through the courts, if you don't address it head on, like Mr. Rhoades is attempting to do in this case, by filing this cause of action within 2 or 3 months of the child's birth, then you have parental-child love and affection, you have bonds, and you have tragedy that's far greater than the situation that has happened here. In Henshaw versus Henshaw, which will be addressed today, okay, it's clear that the trial court found that there was a relationship between the husband and child. In Justice Minton, when he was on the Court of Appeals, wrote an opinion in the SRD case in which there was a similar situation between a 9-year-old girl, Haley, and the person who she thought was her father. The right way to handle this situation is to be honest with one another with regard to who this child is and how this child came into the world.
If we don't place such a high value on an intact structure of society such as a family, then why do we let murderers walk out of these courtrooms under the spousal privilege? I mean, should we do away with all of that? If we're not really wanting to protect, a mother and a father and a child.
Well, the question hinges on who the mother and the father are. But the spousal privilege may relate to those criminal cases, but I don't believe that they relate to paternity.
It's designed to protect the marriage, which has been highly valued in society. You agree with that point, that it has been highly valued, such as that we bend to other rules to protect it.
Justice Scott, there is no question that marriage has been highly valued in our society. Not every marriage is highly valued by the parties to that marriage. And in this case, we have a situation where one party to the marriage did not value and should not be afforded the same protection.
Have we not also equally recognized the right to dissolve a marriage under no-fault principles? If the marriage is valued when it is created, we have certainly recognized the rights of individuals not to be forced to stay in a marriage that isn't working, haven't we?
Yes, Justice Noble, and there is no guarantee that this marriage or any other will continue until past the age of minority for these children.
Isn't there a thread running through the Supreme Court analysis of these problems through Lair in 83 up through Michael or Gerald D. in 89 that the decision's really involving whether or not the marriage is intact?
No, Justice Scott, that's not the way that I would read them. I would read the first 4 cases, that is, excluding the Michael versus Gerald D. case, as stating that a biological parent has rights, has equal protection rights.
Yeah, but those are putative father cases.
Those are all putative father cases.
Yes, I'm talking about.
The final case, Michael versus Gerald D., related to whether a California statute passed a constitutional muster. And in a plurality opinion, the court found that it did. But it's important to look at that swing vote. That is Justice Stevens, who seems to say that the only reason it passes constitutional muster is because the putative father could be considered for visitation even though he wasn't the paternity father.
One last question, and
yes,
I'll let you go to others. But would you agree with me? And I know that these are well-written briefs, and your arguments are excellent, and it is a question that requires deep analysis by us. But would you concede that your definition of parent would allow a rapist to attack an intact family as a parent, if were he the biological father of the child?
It would allow him to come to court,
yes,
and to have a trial.
He would have
the best interest standard applied in that case like every other case.
Counsel, you'll have 1 minute to wrap up.
Thank you, Your Honor. Fundamentally, I believe that this case is based on truth. In Kentucky, every witness has to swear to tell the truth. Every trial is about a search for truth. And the decision will be about more than paternity. It will be about more than family law, and it will apply in every case. The question the court has to consider is whether it will take up a case and make a decision of paternity based on truth or fantasy. We propose that truth must prevail.
Thank you, counsel. Mr. Waterman, you'll have your rebuttal.
Thank you, Judge.